Okay, about mental health and the law. A fundamental principle of medicine is that patients who are capable of doing so are free to make decisions about their treatment, even if those decisions seem imprudent. And this is no different in psychiatry. However, the very nature of mental disorders can affect some patients' ability to make decisions regarding their care and treatment. In these instances, decisions may need to be made without the informed consent or agreement of the patient. Treatment against patients' wishes is usually only considered when the patient would otherwise be at significant risk to themselves through self harm, suicide, self neglect, or exploitation, or may place others at risk. Mental health legislation is therefore in place to protect patients and the public. Differing legal systems within the UK mean that there are differences in mental health legislation across the home nations. This book will focus on mental health legislation acceptable in England and Wales. So we are talking about UK in general. Okay. And American textbooks, of course, would talk about, American guidelines. So let's talk about Mental Health Act 1983 as amended by the Mental Health Act 2007. In England and Wales, the Mental Health Act 1983 as amended by the Mental Health Act 2007 MHA provides a legal framework for the care and treatment of individuals with mental disorders. The MHA is divided into a number of parts, each of which is divided into sections, group of paragraphs. Part 1. Definitions. The term mental disorder is defined as any disorder or disability of the mind. However, the learning disability qualification states that a person with a learning disability or intellectual disability alone can only be detained for treatment or be made subject to guardianship if that learning disability, intellectual disability, is associated with abnormal, aggressive, or seriously irresponsible conduct. The appropriate medical treatment test stipulate that for long-term powers of compulsion, longer than 28 days, it is not possible for patients to be compulsorily detained or treated unless medical treatment is available and appropriate. Medical treatment includes not only medication but also psychological treatment, nursing, and specialist mental health habilitation and rehabilitation. Certain officials and bodies are designated to carry out specific duties related to implementation of the MHA. Some of these are summarized in the table below. So, for the approved mental health professional, AMHP, the description is a mental health professional, nurse, social worker, occupational therapist, clinical psychologist, with specialist training in mental health assessment and legislation approved by the local authority. Duties of an AMHP include assessing patients and, if appropriate, making an application of Mental Health Act 2007 MHA detention. In Section 12 approved doctor, a doctor approved under Section 12 of the Mental Health Act as having expertise in the diagnosis and treatment of mental disorders. Section 12 doctors are responsible for the assessment of patients and for recommending MHA detention detention if appropriate. Approved clinician and responsible clinician. A healthcare professional, usually a doctor, but can also be a nurse, social worker, occupational therapist, clinical psychologist, who has received specialist training and is responsible for the treatment of individuals with mental disorders detained under the MHA. An AC, which is the approved clinician in charge of the care of a specific patient, is known as responsible clinician for that patient. The responsibility is to oversee the care and treatment of a patient detained under the MHA and to remain responsible of administrative duties of the MHA pertinent to the patient. Second opinion approved doctor, which is appointed by the Care Quality Commission, CQC. The role of the second opinion approved doctor is to provide an independent second medical opinion regarding treatment in patients subject to prolonged compulsory treatment who are unable to consent to their treatment, or when a patient refuses electroconvulsive therapy, ECT, not acceptable in emergency situations. Nearest relative. Nearest relative, the spouse, child, parent, sibling, or other relative of a patient detained under the MHA. This sometimes varies from next of kin. It is the duty of the HP to appoint the nearest relative. Although this decision can be appealed in court, AMHPs have a duty to inform the nearest relative of the application of MHA detention. Nearest relatives can, in some instances, apply for the patient to be discharged from compulsory measures. Independent mental health advocates. Advocacy is a process of supporting and enabling people to express their views and concerns, access information and services, defend and promote their rights and responsibilities, and explore choices and options. Most patients detained under the MHA have the right to access an independent mental health advocate. Care Quality Commission. An independent health and social care regulatory body that oversees the use of the MHA and ensures the standards are maintained. All NHS and social care providers involved with the care of patients detained under the MHA must be registered with the CQC, Care Quality Commission. Mental Health Tribunal. Mental health tribunals, MHTs, here appears against detention under the MHA. Their members include a lawyer, a doctor, and a lay person. MHTs have the authority to discharge patients from compulsory measures when they determine that the conditions for detention are not met. Mental Health Act. Mental Health Act managers, hospital managers, represent the hospital responsible for a detained patient. Hospital managers will hear appeals from patients against their detention and review renewal of lengthy detentions. Causes are heard in similar settings of those heard by MHRTs, and Mental Health Act managers have the authority to discharge patients. Let's get back to the text. Okay. Here we have some hints and tips. Okay, here we have some hints and tips. Note that the Mental Health Act 1983 does not regard dependence on alcohol or drugs alone as evidence of a mental disorder. However, mental disorders that arise secondary to substance intoxication or withdrawal, like delirium tremens, drug-induced psychosis, are covered by the MHA. So, we are done with part 1. Part 2. Part 2 of the MHA relates to compensatory assessment and treatment, both in hospital and in the community. Let's go to another table that's talking about civil sections enabling compensatory admissions. So again, part 2 is related to compensatory assessment, compulsory assessment and treatment. Okay, we have these sections. Section 35, remand to hospital for report on mental condition. The aim to prepare a report on the mental condition of an individual who is charged with an offense that could lead to imprisonment. So this is something, okay. The duration here is 28 days with option to expand to 12 weeks. The application on Crown or Magistrates Court on evidence of one doctor who must be Section 12 approved. And we've talked about Section 12 approved doctors. These doctors that approved under the section as having expertise in the diagnosis and treatment of mental disorders. No? Okay, we've talked about that. While in Section 36, remand to hospital for treatment, to treat an individual who is charged with an offense that could lead to imprisonment. The duration of 28 days with option to extend to 12 weeks. The same thing here. Court Crown on evidence of 2 medical doctors, but this time 2 medical doctors, one of whom must be Section 12 approved. Section 37, hospital order, detention and treatment of an individual convicted of an imprisonable offense, similar to Section 3. Initially 6 months with option to extend. This is also Crown or Magistrates Court on evidence of 2 medical doctors, one of whom must be Section 12 approved. And Section 41, restriction order. The aim here is to leave and discharge of Section 37. Patient may only be granted with approval of the Home Office, recorded as 37/41, applied to serious persistent offenders. As for Section 37, the application will be in Crown Court only on evidence of 1 medical doctor who must be Section 12 approved. So, let's continue with that. So, normally the process starts because concerns are raised about an individual's mental health. Following assessment by appropriate professional, the patient may be admitted to hospital under Section 2 or 3 of the MHA. In an emergency, it may not be possible to arrange a review for consideration of Section 2 or 3. In these cases, there are various options available, depending on circumstances. When any emergency measure is used to detain a patient, this should be reviewed as soon as possible by the appropriate professionals and compulsory measures either revoked or a Section 2 or 3 granted. Under Section 135. An approved mental health professional may apply to a magistrate or for a warrant, which allows the police to enter private premises in order to remove someone with a possible mental disorder and take them to a place of safety, usually a police station or hospital, for further assessment. An amendment 2017 also allows the mental health assessment to occur in the private premises. If the occupier consent. Section 136 applies when a police officer has concern about an individual's mental health in a place that is not the person's dwelling. However, the police officer need not apply for a warrant. Patients admitted to hospital on an involuntary basis are informed of their detention and their rights. They may apply to have their case reviewed by a mental health review tribunal or by the Mental Health Act manager when the hospital, both of whom have the power to remove the detention. Patients may also be discharged from their detention by the responsible clinician or by their nearest relative, unless the right to do this is blocked by the responsible clinician. For patients liable to be detained under Section 3, it may be appropriate to consider the use of a Community Treatment Order, CTO, under Section 17 of the MHA. This can be useful when treatment in the community is an option, when the associated risk of mental disorder do not necessitate ongoing hospital admission. Conditions such as attending appointments may be enforced. Conditions such as attending appointments may be also enforced. However, specific treatment cannot be forcefully given. The CTO allows the responsible clinician to recall the patient to hospital should the patient become non-concordant with treatment or should they become unwell. Here we have some hints and tips. Note that the term informal applies to hospital patients who not are detained under the Mental Health Act 2007, like patients who have agreed to voluntary admission. Okay. Another hint and tips. Section 5.2, doctors holding power may be enacted by any hospital doctor provided they are either the responsible clinician or another doctor nominated by them, like specialist registrar or senior house officer. Okay, either specialist registrar or senior house officer. This means that a psychiatrist need not see suspected mentally ill patients on a medical or surgical ward before they can be detained under this section. Okay. What about part 3? Part 3 about forensics, it is the forensic section. Part 3 of the MHA incorporates section 35 to 55 and relates to mentally ill patients involved in criminal proceedings or under stance. Here we have a table that summarizes the most important sections in this part. This is it. Forensic section. We will go quickly through it. Section 2, admission for assessment. The aim of it is to provide compensatory detention for assessment used when diagnosis and response to treatment are unknown. May be converted to a Section 3 if longer admission needed. Medication may be given as part of the assessment process. The duration is 28 days, and the application by approved mental health professional. And the recommendation would be 2 doctors, at least one of whom must be Section 2 approved. Section 3 admission or treatment. Compulsory detention for treatment used when diagnosis and treatment response is established and may be extended to 6 months. The application also approved mental health professional AMHP. And the recommendation by 2 doctors, at least one of them must be Section 12 approved. Section 4 emergency admission or for assessment. Emergency admission to a hospital for assessment when there is no time to wait for Section 2 procedure in the community. The duration would be 72 hours by the MAMHP, and the recommendation would just be from one doctor with full GMC registration, usually FY2 or above. Section 5.2 doctors holding power. Detention of a hospital inpatient receiving any form of treatment, not necessarily psychiatric, in order to give time to arrange review for a Section 2 or 3 for 72 hours, and it can be recommended by doctor responsible for patient's care or other nominated doctor with full GMC registration. Section 5.4 nurse holding power. The aim here is urgent detention of an inpatient receiving treatment for a mental disorder to allow for review by doctor. It can be up to 6 hours and can be recommended by a registered mental health nurse. Section 17 community treatment order allows for supervised treatment in the community in patients liable to detention under Section 3. Stipulate that patient must attain appointments, may be recalled to hospital if non-concordance with treatment or if they become unwell for 6 months by responsible clinician, and can be recommended by AMHP and responsible clinician as well. Section 35 allows police to enter private premises to remove someone with a suspected or known mental disorder to a place of safety for further assessment, or to allow an assessment to occur in the private premises if the occupiers agree. It can be for 72 hours by AMHP and recommended by magistrate. Section 136 allows a police officer to remove someone with a suspected or known mental disorder from a place that is not their dwell to a place of safety in their best interest or for the protection of others. If the person is already in a place of safety, a police officer can keep them there or transfers them to another place of safety for 24 hours, and recommended by a police officer following consultation with a mental health professional or practicable. Okay. It should be noted that patients who are detained under certain forensic sections and who are not restricted patients can be considered for supervised community treatment if appropriate. So let's go to part 4. This part of MHA clarifies the extent to which treatment can be imposed on patients subject to compulsory measures. Patients detained under Section 3 or 37 long-term treatment order may be treated with standard psychiatric medication for 3 months with or without their consent. However, after 3 months and in other special cases, an extra section from the second opinion approval doctor is required for treatment. Such cases include psychosurgery and surgical implants of hormones or to reduce sex drive. These require the informed consent of a patient with the capacity to make such a decision, as well as the approval of SOAD under Section 57 of the MHA. Neither of these procedures can be carried out on a patient who lacks capacity to make these decisions. A second case, administration of medical treatment in a patient who cannot provide or refuses to provide informed consent. This requires the approval of SOAD, which is the second opinion approved doctor, under Section 58 of the MHA. ECT also. ECT, if the patient is capable of understanding the nature, purpose, and likely effect of the treatment, then electroconvulsive therapy cannot be given without his consent. If the patient lacks capacity then ECT must be clarified as appropriate by a second opinion approved doctor under Section 58A of the MHA. In circumstances where urgent treatment is required to save the patient's life or to provide serious suffering or to provide. Okay. So, in circumstances where urgent treatment is required or to save the patient's life or to prevent serious sufferings or deterioration, it may be appropriate to use Section 62 to waive the second opinion requirement of Section 57 and 58. For example, emergency ECT for a patient who is not eating or drinking. Section 62 is only used until a second opinion can be obtained. So let's talk about mental health care and treatment in Scotland. Act 2003. Compulsory measures in Scotland are legislated for by the Mental Health Care and Treatment Scotland Act 2003. They can be used when a patient is suffering or thought to be suffering from a mental disorder, mental illness, intellectual disability, personality disorder, by virtue of which the individual's ability to make decisions about treatment of their mental disorder is significantly impaired. When treatment for the mental disorder, including medication, nursing, and psychosocial care, is available, and if there would be considerable risk to the health, safety, or welfare of the individual or the safety of others without treatment. The use of compulsory powers must be considered necessary, and lesser restrictive options must be deemed inappropriate. The use of the Act is overseen by the Mental Welfare Commission of Scotland under civil law. The following orders are frequently used. First, emergency detention certificate. An emergency detention certificate allows an individual with mental disorder or suspected mental disorder to be detained in hospital for up to 72 hours. Where hospital admission is required urgently for assessment and when application for a short-term detention clarification would cause undesirable delay. Any doctor with full GMC registration can implement an EDC. You know EDC, this is it. Emergency Detention Certificate. Okay. So, any doctor with GMC registration can implement the emergency detention certificate. Wherever possible, the agreement of a mental health officer, MHO, usually a social worker specially trained in mental health, should also be obtained. Patients may not be treated against their will under the EDC, but emergency treatment is possible under common law. It should be reviewed as soon as practical by an approved medical practitioner, a psychiatrist with special training and approved approval in the use of the mental health care and treatment in Scotland, and should either be revoked or converted to an STDC, which is the short-term detention certificate. The STDC allows an individual with a mental disorder or suspected mental disorder to be detained in hospital for up to 28 days. It can only be applied by an approved medical practitioner in agreement with a MHO. Patients may be given treatment for their mental disorder under an STDC. Patients have the right to appeal the STDC at any time, with their appeal being heard at a tribunal. The STDC may be revoked, or an application for a CTO may be made. What about compulsory treatment order? A compulsory treatment order usually follows an STDC. An MHO applies to the Mental Health Tribunal for Scotland, asking them to consider granting a compulsory treatment order. This requires 2 written medical reports, usually completed by the responsible medical officer, the approved medical practitioner responsible for the care of the patient, and the patient's general practitioner, GP. It also requires the proposed care plan detailing medical treatment that would be provided if the CTO is granted. The tribunal consists of a lawyer, a doctor, and a layperson. They decide whether the application is appropriate before granting the CTO. Refusing the CTO or suggesting an interim order while further information is gathered. A CTO lasts for 6 months initially. However, application can be made to the Mental Health Tribunal to extend this. Patients have the right to appeal. CTOs can be used to treat patients in the community as well as in hospital. What about mental health in Northern Ireland Order in 1986? The Mental Health Northern Ireland Order 1986 is similar to the Mental Health Act of English and Wales, although there are some noteworthy differences. Unlike other UK mental health legislation, the order defines the mental illness. Mental illness means a state of mind which affects a person thinking, perceiving, emotion, or judgment, to the extent that he requires care or medical treatment in his own interests or the interest of other persons. The various paragraphs are referred to as articles, not sections. The order does not allow for the detention of individual with a personality disorder or sexual deviancy or dependence on alcohol or drugs, although individuals may be detained when a personality disorder coexists with mental illness or severe mental impairment. There is only one procedure of admission to hospital. All patients compulsory admitted to hospital will be held for a period of assessment lasting up to 14 days. Following this, they may be detained under Article 12, which allows detention for treatment for up to 6 months, beginning with the date of admission. The application of assessment is made either by the nearest relative or more commonly by an approved social worker. This application is founded upon a medical recommendation, which must be made by a registered medical practitioner, usually the person's GP. The orders stipulate that a patient admitted for assessment should be examined by a consultant psychiatrist within 48 hours of admission and during the second 7 days of assessment period. The Mental Capacity Act Northern Ireland 2016 is due to come into force in 2020. This new legislation will supersede the 1986 Mental Act Order. Innovatively, it combines legislation regarding treatment for mental health problems with treatment for those who lack capacity for any reason. What about capacity to consent to treatment? Mental capacity is defined by the Mental Capacity Act 2005 as the ability of the individual to make their own decision. An individual aged 16 years old or older has the capacity to make a specific decision if they can communicate their decision, understand information given to them to make a particular decision, retain that information and balance or weigh up the information to make the decision. Communicate the decision, understand the information, retain the information, and balancing. Hints and tips. Capacity assessment can be remembered by almost the same acronym as the common pneumonia severity assessment, which is CURB. Communicate, understand, return, and balance. Okay. Communicate, understand, retain, and balance. If an individual is unable to do one or more of the above, they lack the capacity to make the particular decision in question. It should be noted that capacity is not a blanket term, and it should be considered according to the decision to be made. For example, a woman with a moderate intellectual disability may have the capacity to decide to buy music by her favorite singer. However, she may lack the capacity to make a decision to take out a mortgage to buy a house. Under the MCA, an individual must be assumed to have capacity until it is established that they lack capacity, and should not be treated as incapable until all practical steps to help them have been taken without success, and must not be treated as incapable merely on the basis of wishing to make an unwise decision. Any act done or decision made under the MCA must be in the best interest of the individual, must be undertaken in a manner that is least restrictive to the individual's rights. Here we have an ethics point. A patient should by default be assumed to have capacity unless it has been demonstrated they do not. Making an unwise decision does not by itself demonstrate incapacity. The framework used to assess mental capacity in Scotland and in the adults with incapacity, Scotland Act 2000, and in Northern Ireland and Mental Capacity Acts, Northern Ireland 2016. Okay, with regard to medical treatment, clinicians should provide patients with a clear explanation of the nature and likely benefits of a treatment, as well as its potential risks and side effects. An adult who has capacity has the right to refuse treatment, even if this refusal results in death or serious disability. When patients refuse essential treatment, clinicians should ascertain whether they have the capacity to consent to treatment and have made a free decision without coercion. When making decisions about capacity, you should not hesitate to discuss the case with colleagues or even a medico-legal defense organization. The process of assessment should be clearly and comprehensively documented in the medical notes. Okay, here we have a red flag. An adult who has capacity has the right to refuse treatment, even if this refusal results in death or serious disability. In such cases, it is important to document carefully the assessment of capacity and to discuss with senior colleagues. deprivation of liberty safeguards. The deprivation of liberty safeguards is an amendment to the Mental Capacity Act 2005, which applies only in England and Wales. These safeguards do not apply to someone detained under the Mental Health Act. If a person who lacks capacity in a care home or hospital needs to have their liberty restricted, like they are not free to leave or are subject to continuous supervision and control, then an application to the local authority needs to be made for a standard authorization. Issuing such an authorization ensures that safeguards for the patient are in place, including appointing a patient's representative, the right of appeal and access to advocacy. Advanced decisions. An advanced decisions or living will. An advanced decision or living will is a statement of an individual's wishes regarding the health care and medical treatment they would wish to have or not wish to have. So, if they were to become incapable of making decisions on these matters in the future, the individual must be over the age of 18 years and must have capacity to make this statement. The advanced decision can become valid when the individual loses capacity to consent or refuse treatment in the future. Advancce decisions are legally enforceable under the MCA in England and Wales. In Scotland and Northern Ireland, the equivalent of advanced decision is called an advance directive. Respecting the advance refusal of a competent adult is also a requirement of Articles 5 and 8 of the Human Rights Acts in 1998. A principle underlying decision-making on behalf of all those without capacity is that the previous known wishes of the individual should be taken into consideration, whether or not they are written down. Proxy decisions. Proxy decision-making. A power of attorney is a legal document that enables an individual who has capacity and is over the age of 18 years to nominate another person, attorney, to make decisions on their behalf in the event that they become incapable of doing so in the future. The type of decisions may be specified and may include healthcare, welfare, and financial matters. If the individual lacks capacity and has not made a power of attorney, it is possible for the courts to appoint these powers to individuals. Laws regarding power of attorney vary between England and Wales, Scotland and Northern Ireland. Ethics. Having a serious mental illness does not preclude a patient from having the capacity to consent to physical treatment, as long as their illness does not interfere with their understanding of relevant information and the decision-making process. Common pitfalls. The Mental Health Act makes provision for the compulsory treatment of mental disorders only, not for the compulsory treatment for physical disorders. Therefore, a patient can never be detained under the Mental Health Act 2007 to treat a physical disorder. And patients can refuse physical treatment unless they are assessed as lacking capacity. Patients who require urgent physical treatment but who do not have capacity may be treated without their consent, but in their best interest, under the Mental Capacity Act 2005. Common law. Common law refers to law that is based on previous court decisions, case law, rather than laws made in parliaments, statute law. The Mental Health Act is an example of statutory law, whereas providing immediate saving treatment to an unconscious patient unable to consent is justified under common law. The common law doctrine of necessity allows for treatment in emergency situations of physical or mental disorders in adults who are unable to consent. Treatment must be made in the best interest of the individual and must be necessary to sustain life, to prevent serious deterioration, or to alleviate severe pain or suffering. The doctrine of necessity is applicable only in emergency situations, and if necessary, treatment should be continued under statute law, like the MHA and the MCA, as soon as practically possible. Many doctors and nurses who are not familiar with mental health legislation are often concerned about infringing patients. Are concerned about that. Are often concerned about infringing patients' rights and may not act at all. Like a man with a life-threatening alcohol withdrawal delirium is allowed to leave the ward with no one attempting to stop him. When considering an action under common law, always ask yourself whether your actions would be defensible in court. Your actions should be consistent with that most individuals with your level of training would do in the same situation. Choosing not to act when you should is indefensible and would be construed as neglect or negligent. Common pitfall. It is permissible under common law to restrain and medicate patients who are mentally distorted and who present an imminent danger to themselves or others. However, it's not legal to impose psychiatric medication repeatedly on informal patients. Anyone who has required emergency restraint and treatment under common law should be promptly assessed by a senior doctor for treatment under the appropriate section of the Mental Health Act. Human rights legislation. Human rights are commonly understood as inalienable fundamental rights to which a person is inherently entitled simply because he or she is a human being. The Universal Declaration of Human Rights was established in 1948 and subsequently the European Convention of Human Rights in 1953. These are considered to be international law. The UK has introduced its own statute law, the Human Rights Act 1998, HRA. There are some fundamental incompatibilities between the Human Rights Acts 1998 and the mental health legislation. The Mental Health Act 2007 has gone some way to address these. However, it is still important to be aware of some important aspects of human rights legislation and to interpret mental health legislation in a way compatible with the Human Rights Act as far as possible. Article 3 of the ECHR states that no one shall be subjected to torture or to inhuman or degrading treatment or punishment. This is an absolute right and is always applicable when a patient is in hospital, wherever detained or not. Practices that could be considered to be inhuman or degrading may include the use of excessive force during restraint, maintaining high levels of sedation to compensate for staff shortage, a lack of privacy or adequate sanitation, or treatment without consent in cases where it is not medically necessary under common law or under the MHA. Public authorities have a duty under the HRA to protect the human rights of patients in their care. Article 8 of the ECHR protects the right to respect for private and family life, home and correspondence. It also sets out in general terms circumstances when an interference, also known as a restriction with this right, is acceptable. However, interference must be lawful, necessary, and proportionate. Under mental health legislation, seclusion, keeping and supervising a patient alone in a room that may be locked, can occasionally be used. However, if this is not justified as being lawful, necessary, and appropriate, it may be a violation of the human rights of the patient. Article 5 of the ECHR protects the right to liberty. However, it also sets out specific circumstances in which this can be limited. Inappropriate use of the MHA, including undue delays in tribunal or appeal process, can result in an unlawful restriction of liberty, which may be in violation of Article 5 of the ECHR. There are also instances when failure to use mental health legislation appropriately may be considered to be in violation of the individual's human rights. Article 2 of the ECHR is an absolute right to life. Professionals or authorities who fail to protect life may be considered to be in violation of the law. Failing to detain a severely depressed and suicidal patients who later committed suicide was considered by the UK Supreme Court to be a violation of Article 2 of the ECHR. The interference between mental health legislation and human rights legislation is incredibly complex and beyond the scope of this book to discuss in detail. However, it is important to be mindful of human rights law and these potential difficulties, and to seek advice from an expert if in doubt. Fitness to drive. Driving is a complex skill requiring good sensory ability, vision, hearing, good motor control, power, coordination, reaction time, good memory and good executive function, attention and concentration, judgment, planning and organization, ability to self-monitor. It follows that many mental illnesses and psychiatric medications can impair fitness to drive. Clinicians should be aware of the following legal provisions. It is the responsibility of the Driver and Vehicle Licensing Agency, DVLA, to make the decision as to whether an individual is fit to continue driving. It is the driver's responsibility to inform the DVLA of any condition that may impair his or her driving. A patient with a condition requiring notification should not drive until they hear back from the DVLA and must not drive during an acute illness. It is the doctor's responsibility to advise patients to inform the DVLA of any condition that may interfere with their driving, like psychotic episode, manic episode, and dementia. Here we have a table that would say something about these conditions. Doctors may be contracted by the DVLA for further clinical information or may be invited to prepare medical report. Here we have some common mental conditions about which the DVLA should be notified. Conditions like anxiety or depression, mild to moderate, without suicidal thoughts, agitation or significant memory or concentration problems. These patients can continue to drive, no notification is required. While depression or anxiety, severe, that causing significant memory or concentration problems, agitation or suicidal thoughts, license revoked until a period of stability has been achieved, typically 3 months. Acute psychotic episode, license revoked until stable with good insight for 3 months. Hypomania and mania, the same thing. License revoked until stable with good insight for 3 months. Schizophrenia must not drive during acute illness. After 3 months of stability, licensing can be considered even if continuing symptoms, as long as these are unlikely to affect concentration, memory, or causing distraction while at wheel. Neurodevelopmental disorders like ADHD may be able to drive but must notify DVLA. Dementia may be able to drive but must notify DVLA. Early dementia may be licensed with annual review. Impairment in short-term memory, disorientation, or lack of insight suggests unfit to drive. Learning disability, mild, may be able to drive but must notify DVLA. Driving assessment may be required. Moderate to severe, should not drive. Personality disorders with severe behavioral disturbance may be able to drive but must notify DVLA. Persistent harmful use of alcohol or alcohol dependence, license revoked until a minimum of 6 months or 1 year free of alcohol problems, depending on severity of use. Persistent harmful use of substance or dependence, license revoked until a minimum of 6 months or 1 year free of substance, depending on substance. If multiple substances used, unlikely to be licensed. Methadone or buprenorphine can be compatible with driving. Any other psychiatric condition that impair concentration or awareness, increases distractibility, or in any other way is likely to affect safe driving of the vehicle. It should be case specific, of course, likely that a period of stability required. Okay. Medications that can influence safety. Okay, we are done here. Okay. Medications that can influence safety to drive are those that impair alertness, concentration, or coordination. Many medications used in psychiatry are sedating, like tricyclic antidepressants, and or can affect motor control, like antipsychotics. And patients should be advised not to drive immediately after starting or increasing the dose of such medication. Those who are not adversely affected can continue to drive. This is particularly important for professional drivers. Doctors have a duty to breach confidentiality considerations and contact the DVLA medical advisor themselves if patients fail to take this advice and the potential impairment is serious. The same applies to patients who, due to their illness, for example dementia and psychosis, are unable or unlikely to contact the DVLA. Ethics. In order to protect the public, doctors have a duty to break confidentiality and inform the driver and the vehicle licensing agency if they become aware that a patient is continuing to drive or is likely to continue to drive against medical advice. Chapter Summary. Patients who have capacity are free to make good or bad decisions about their health care. Patients who lack capacity may need decisions to be made for them in their best interest. Legislation exists to ensure this is done only when necessary and in a way that protects patients' rights. Mental health legislation in the UK allows people with significant impaired decision-making ability to be detained in hospital for assessment and to be given treatment for a mental disorder against their will. Many capacity legislation in the UK allows people who lack capacity to be given treatment for physical disorders and to be accommodated against their will. Common law allows immediate treatment to be given to people who cannot consent in emergency situations in order to prevent serious deterioration, severe pain, or death. Severe mental health problems often impair driving and require the driver and vehicle licensing agency to be notified. A license is often returned after a period of stability. So that's it about mental health and law. Next, we will talk about mental health service provision, a very important chapter. هذا والله تعالى أعلم وصلى الله وسلم على سيدنا محمد وعلى آله وصحبه أجمعين.